Hey, Bill Henshaw, Constitutional Crisis Channel. You haven't seen me on a video like this, but I'm on vacation with my sister helping her take care of some business. And I'm going to do a few while I'm back here. And I've got big news coming up. First, I just want to say I'm glad I'm back and we'll get things done as quickly as possible. And I'll get back on my YouTube channel and communicate. But best to reach me with my email, ccaspari@live.com. And I've have document packets available. Now the change will be, I don't have these yet. I've been doing it defensively with a perfect record. Got a better record than Gino Auriemma up here in Storrs, where I'm near UConn with the women's basketball team. I win more than he does. But now I'm headed to doing offensive cases. This is really going to be exciting with the information I'm going to put out tonight. I'm still researching and analyzing it, but I'm comfy enough to talk about it. And it deals with the subject called ratio of representation. And it's not what you think. And this, by the way, if you've been following videos, I've been doing things on what I call Article 1, Section 2, Clause 3. 1, 2, 3. It may be as easy as that. Because when you read that and you understand the way I read the Constitution, but not the way they currently read it in the Supreme Court and in the other division of government, you know, you have to have one representative for each 30,000. That's the upper limit. But that's not what we have now, and this undoes the whole thing. I'll go more into it in a bit. I got a couple of key cases I've been looking at called Franklin v. Massachusetts and Department of Commerce v. Montana, decided within 2 years of each other about the 1990 census. And you will be shocked with what, and it's a dead giveaway. I think this is the smoking gun we've been looking for, because they can't do any of what they're doing here unless we don't have states, because we would have big separation of powers, because 1, 2, 3, that's Congress, that's legislative. Not only has the court said in the Franklin case that they can delegate the authority to the Secretary of Commerce, which is bad enough, and especially when one understands that the court has earlier said that the Commerce Clause jurisdiction of Congress is closely associated with the Admiralty and Maritime jurisdiction. That's where we get trouble, because, you know, they've also, the framers of the Constitution identified that in the Declaration of Independence as a jurisdiction foreign to our Constitution and unacknowledged by our laws. What the hell is going on here? So to give this to Secretary of Commerce, who's in the executive department, that's problem number 1. Problem 2 is Admiralty. And problem 3 is the Secretary of Commerce doesn't have the final word on the census or the number of representatives that each state is supposed to have. The president has been delegated that authority. And I'm going to challenge you to look in Article 2 of the Constitution, see if you can find any possible power he could exercise, even if he could be delegated this authority. And I'm going to help you out. There's only 2. That's his power as Commander-in-Chief of the Armed Forces, which is exactly what I think it is, and I think I can prove it. Or his power to, under the Appointments Clause, Article 2, Section 2, Paragraph 2, to appoint officers of the territorial governments. Those are the only 2 I can see. The only other possibility is that Congress is saying, okay, we're now doing apportionment, but we're using Article 4, Section 3, which says Congress can pass all needful rules and regulations in the territories. Now, they can't use any of those against anybody that goes into court with any intelligent plan like the one I am hopefully putting together here, and make those arguments, because they're going to have to admit they're not states, they're something else. Once that happens, they then have to show a provision of the Constitution which allows them to do it. And there isn't one. That's where we get the 14th Amendment. That's the only place they have to go. And I'm sitting here at the moment with a 65-page unopposed brief on the admission of new states. With these 2 cases you're going to hear about, that's going to probably get to be over 70 pages. And no one's even attempted to oppose it in 4 decades. This is where we get the bastards. Now we can prove it and say you can't possibly do any of what the Supreme Court is talking about in Franklin or Montana, unless we're talking about territories, because you wouldn't have any separation of powers problem there at all. And then Congress can say it can be whatever amount of representatives we want. and it's currently limited to 435 and has been for over 100 years. I'm just getting the hard copy law on that now. But think about it, if we're supposed to have one for every 30,000, and we now have a population of approximately 315 million. I've done the math, simple math. How many are we supposed to have in Congress and the House of Representatives? 11,500. Whoa. What does this mean? Not only are they in violation of 1, 2, 3, but they can't possibly have a quorum to do business in either the House or the Senate. And the Senate's vacant, by the way. We'll get to that later. But trust me, there's nobody in the Senate, haven't been appointed by the legislatures. So we got a null Congress, and we can challenge any act that they've done. And for me, particularly juicy is the Federal Reserve Act of 1913, when they would have had to have around 3,300 members, and they didn't. I mean, this is where it's hardball. It's the only way to say it. And you're going to have to stand up and not be afraid to do it. And you shouldn't be, because we're right, they're wrong, and there isn't any two ways about it. So with these two cases, and the court saying they can delegate this authority not only to the president, but apparently unreviewable. So that makes it either a quote-unquote political question, or it means that we're dealing with territories, because they can't possibly do this if they're going to say, for example, Article 4, Section 4, where it says the United States guarantees to each state a Republican form of government. If that's a political question, then we have no hope. I mean, are they going to tell us that the framers were stupid enough to put a provision like that into the Constitution that was dead on arrival, DOA? It could be done away with legislatively, by 1, 2, 3, and getting rid of the states. I'm not going to buy that for a minute. And by the way, note carefully, the cases I'm talking about and all of the cases on this subject matter don't come anywhere near the issues I'm raising here. They all assume everything is copacetic, it's perfect, and that's the way it is. And by the way, the Montana case, it gets worse in some respects, because the court, in discussing, because Montana had lost a representative in this latest census, and what happened was the state of 800,000 went from 2 representatives to 1, and the court regretted this in their opinion, saying that that violates what they call the ideal standard for the House of Representatives, 1 to every 540,000 at that point in time. It's now 1 to about every 880,000 instead of 1 to 30,000. You can see the problem. But they had no problem with that, and they won't have any problem with it now with the current determination. They're completely wrong about this. I can't believe, and nobody, and the states that go in there with the attorney generals and all the attorneys, none of these questions are anywhere close to being asked and answered. So the court can, console themselves when they go to bed and say, well, you didn't ask, we're not going to answer. That goes into their Ashwander doctrine, which I've talked about on earlier videos, the 7 rules for status and standing. The good news about it is it helps us unbelievably, because once you understand these rules, and you understand that the court has said we will not construe a constitutional law broader than the case to which it is to be applied. Now we go in and follow up Franklin and Montana, for example, and say, wait a minute, we're not asking any questions under the Administrative Procedures Act, a statutory act of Congress. And I agree with what they did, but they should have had the integrity to say what the hell they were doing. But we have real constitutional issues, and we're entitled to go there in the first instance. That means you go right from the traffic court when they either don't file your documents, as I recently had happened to me in the Miracle and Merced case, and I've got an offensive lawsuit on the way with that right now. Probably won't have to file a thing, and just say, hey, lay it out to you on a documentary, dead bang, evidence you're as guilty as sin here. Pay up and be lucky. That's all that's going to happen to you. And that's what I'll be able to do for you people out there, even with one traffic case, because they're either going to refuse to file the documents, or if they file them and you actually get a motion hearing set, it's going to get canceled. The DA is not going to answer the paperwork, and you're going to be in the same situation. You're going to love it. Because the Supreme Court has clearly said this kind of a situation where you don't have any opportunity to be heard. And trust me, in 7 months as a political prisoner in Colombia, I never had a chance to be heard. 7 months. and they are going to be paying me the rest of my life once I get the case settled. It's taken a while because of the very situation we're talking about. But when I get there, and I will, they know I've got them dead bang all the way to the governor's office, and with criminal charges. That's how you get paid off quick. And it's what my record in support of your record is going to do for you. And quickly, like we just had a recent case in Utah that a girl, you probably saw it on the internet, a nurse got arrested when she prohibited a cop from taking a blood sample from a patient who was unconscious. Now, actually, I think she was probably wrong on the law. If you know a case called Schmerber v. California, going back to the 1950s, the court probably would have sustained that. Nevertheless, the authorities in Utah plainly admitted they were wrong in this, that, and the other, and she got a hold of an attorney, and she just recently got a settlement for like $500,000. And my cases are even better with the amount of premeditated criminal acts they do. And in my case, they reach all the way to the governor's house and to the Chief Justice of the state Supreme Court. Those are the kind of people that are going to have liability. That's why they pay you off. They can't afford to take that chance, even with this civil rights lawsuit, which I would never file on my own, but I can do it in other cases if we have to. I don't think it's going to be necessary. I really don't. This is big news because if this business with 1, 2, 3, it exposes the whole fraud. I mean, they can't get out of it any other way. They're not talking about states anymore. They're not talking about the Constitution that you and I were brought up to believe existed when we were in their mandatory school system. It's not even close to that. And now I think we have a way to get it out there and leave them no way out. Absolutely none. So that's where we're headed with these two cases. You'll get more on this in videos and in documents I'm preparing now to go into document packets. So you'll have a copy of these things. And I would, and you would love to be a fly on the wall when the DA gets these in their office and sees these kind of issues. We're not going in there and saying 4th, 5th, and 6th Amendment. Who the hell cares about that? The Bill of Rights, if you don't know, doesn't apply to the states. I got the Supreme Court saying it. And that's the first thing I said in Columbia in the hearing I had, quote unquote hearing. And I shocked the courtroom into silence. Not 2 words. Judge and I went back and forth, respectful conversation. I clearly got the better of it. But the first thing out of my mouth was Barron v. Baltimore. Supreme Court said, Supreme Court said, the Bill of Rights don't apply. What are we talking about here? They were trying to find out whether I was, quote unquote, competent to represent myself. Well, Judge, I'm not here pro se. I'm here in my own proper person. I don't need your permission to be here. That's the kind of attitude you want to express. And those of you, by the way, familiar with one of my favorite movies, Shawshank, take a look at the end of the movie with the last parole hearing of Ellis Boyd Redding. That's the attitude that you want to copy. When he's been there for 40 years and they say, are you rehabilitated and want to get out? And he says, well, he doesn't know what rehabilitated is, except it's a word for you people to have a suit and tie and have a job. So stop wasting my time, money, Sonny, and sit down and just stamp your forms. He got released. That's the attitude you want to give him, and it's not that hard to do. But look at that whole movie. That's absolutely brilliant. Not because it was set in jail, but because of what they showed you about the ability to think long term. And I'll talk more about this picture in a later video. We're not going to do it tonight. But that's the reason it's right up there, number 1 or 2. It depends on the day of the week, because I've got Amadeus in the mix there too, but story for another day. But you start developing that kind of attitude, and you have some sense of self-esteem. That's what it is they want to take from us and reduce us to peons that are dependent on them for an existence. You know, every collectivist government worthy of the name, that's the goal they want. They don't want you to know you have the power, but we have it and they don't. That's how simple that is. Well, I've run on here a little bit, so I'm ready for a couple of questions. If you want to ask some things, I'll fill in some blanks.
Yeah. So what I'm curious about, Bill, is how the number for 123 is fixed at 435 and House members, and that's what we have now. Have you gotten to figure out how the number has been fixed?
I have, Adam, and I don't have hard copy, but this goes back, unlike we originally thought. Actually, Congress passed a statute in 1911 that did limit it to that number. So I don't have.
How can they do that?
Yeah, well, how could they do that given what the ratios? And see, that's what we challenge is unconstitutional. That's exactly the law. Now we're going to get them because they can't show any way without a constitutional amendment to 123 that that would be possible. You know, unless I'm seriously misreading what Mr. Madison said about that in Federalist number 55. And that whole thing is going to be in my brief that people are going to get when they purchase my document packets. And trust me, I believe James Madison, you know, a hell of a lot more than I do Woodrow Wilson. And it comes right down to it. So yeah, they actually did do that. I just didn't get it until I read, I think it was in this Montana case where they had a footnote on this that I came across it just today. So I haven't had a chance to see if I can go get it yet. But 1911 is when this statute was actually passed. So in 1929, as we've discussed, they were talking about it later. They didn't have to pass the law. It was already in existence. That's what they were referring back to as things currently stand is what they're saying. So yes, indeed, 435. And, you know, that's in addition to arbitrary and ridiculous. I mean, it doesn't survive any serious constitutional challenge at all. And especially since we have the Leviathan government we have now that thinks it has control over every aspect of the lives of the American people, to the point that some of you might be familiar, just recently in North Carolina, they had a big to-do there when the courts ruled, for all intents and purposes, that taking a crap in a government-funded bathroom affected interstate commerce.
You've mentioned that a couple times. What case is that? I want to see that.
Yeah, I'm not sure if it's a case per se, but the administrative proceedings, and there was the big deal there was that with quote unquote transgender bathrooms, that they had a problem with that, and that they didn't want to let, you know, guys and girls switch bathrooms in effect. But the preliminary ruling, and if I can find it, I'll get it for you. But in effect, they were operating on the proposition that, you know, that government-funded bathroom affected interstate commerce. That's the only way they could get there. And by the way, that brings up even a better case that people, you need to read this one closely. And if you ask me in my email, I'll send it to you, called United States v. Lopez, 514 U.S. 549. Mm-hmm. And this is a case, the first time at the time in 60 years that the Supreme Court had limited the Commerce Clause powers of Congress. We're now 20 years later, and I don't think there's another time that's happened, so it's 80 years. But during oral argument, the justices asked the solicitor that was arguing the case for the government if there were any areas not under the control of the Commerce Clause powers, and he couldn't come up with a single one. Not a one. This is the kind of crap we have to stop. And by the way, and if you've been paying attention here and you're saying to yourself, wait a minute, if we have no states, which is exactly what I'm claiming, on what political entities does Congress's Interstate Commerce Clause powers act? If there are no states, whoa. And you start raising these kind of questions, and they're legitimate, and you're going to have 150 pages and maybe more in support of it. They can't throw that out as specious, frivolous, and without merit, because we have a right to ask those questions, a right to put a defense on, a right to invoke the judicial power of the United States. And for those of you that don't know, more about it later, but these federal district courts you have in your hometown and whatever, and the federal circuit courts of appeal, those are not Article 3 judicial courts. And that's one of the only good things I took from the recent confirmation hearings of Neil Gorsuch, because I think he learned, as did the other members of the 10th Circuit, about this situation that they didn't know before, because they had made a final ruling on an immigration case that was effectively reversed by the ICE, the administrative arm of the Department of Justice. Well, wait a minute. With the judicial court, that can't happen. It just can't. This goes back to 1792. This is the oldest case I used, called Hayburn's case, and it involved the salary benefits of the veterans of the American Revolution who were getting screwed over like they have been for the 200 years ensuing that. And the justices of the court all respectfully refused to do it and sent President Washington a letter and said, whatever we do can be adjusted by the Secretary of the Treasury. Therefore, that's not a proper judicial function, and we can't do it. Even if we want to, we can't do it. Now, if I could get 5 minutes with Gorsuch and see whether he knows and understands that case, and I'm willing to bet you he does, that may lead to some good things on the court. I'm frankly, like a lot of people, I'm not thrilled the way the Trump administration has gone to this point. But that said, getting Gorsuch on there, and if we get Ginsburg off there with any luck and get a real change there, now we'll have people on there, that we can trust. Although, if I back up a second here and go back to the Franklin case, my disappointment there, I didn't pick it up at first, but when I read who argued that case in front of the justices, the oral argument was Assistant Solicitor General Roberts, now known today as Chief Justice John G. Roberts. I was not happy about that, despite the fact I agreed with him about what the decision of the court should be and what they actually decided. But they should have been arguing much different issues, and he's one that should have known that. With the conservative that he's supposed to be, this is somebody who you would think would know and would have made objections, and he did not do it. So I'm not thrilled with that part. But in any case, this is what we're dealing with these days. It's all interstate commerce, and yet we have no states. And this all goes back, in my view, by the way, to the bankruptcy of the United States, HJR 192 in 1933, when Roosevelt gets in office. And within days, they have this come down. He closes the banks for a bank holiday. And a whole lot of other crap happens. They demand everybody turn in their gold to the federal government under criminal penalties. And a lot of people were stupid enough to do it then. Government can't do that. That would be a clear bill of attainder, taking a property without judicial process. And by the way, one of the last times they ruled on that was a case called Cummings v. Missouri, 4 Law 277, 1872. But I just got a recent case, thanks to Adam here, called Lovett v. United States, much later case where they do talk about this issue in a limited context, but it's a good case. And they do, and another case that they did called Fleming v. Nestor, 363 U.S. 603. And Nestor, what happened there, just a brief story. This is an important one because he'd been in the United States 40 years. He came from Bulgaria or somewhere like in the 19 teens. And he'd worked for 30 odd years under the Social Security system and had accrued benefits. Well, he got expelled from this country during the Red Scare of the 1950s and all that, and Senator McCarthy, for being a member of the Communist Party in the 1930s, when apparently it wouldn't have been a crime to do so. And they took his benefits away, and he said, wait a minute, you can't do that. And he wins in the district court. He wins in the Court of Appeals. They go to the Supreme Court, who says, just like Lee Corso on Saturday afternoons now, not so fast. By 5-4, they ruled against his claim, and the defense attorneys, to their credit, made the argument of bill of attainder. The majority glossed over that like it didn't exist. The dissenters, among them Hugo Black and William O. Douglas, two of my favorites, and they're on most lists of top 10 justices of everybody you can name, were in the dissent here. And they made a big deal about that being a bill of attainder because all those justices on the court knew very well, because they were of age in the 30s when they passed this damn Social Insecurity Act. They knew it was sold to the American people as an insurance annuity. There were property rights. And yet they make this ruling in Fleming v. Nestor that effectively changed the course of American history. So now what they're saying is, and they say it overtly, that I'm going to ask you, Adam, later to get me a copy of this report from the House Subcommittee on Banking and Finance. They said two key things. A taxpayer, quote unquote, has a zero interest in his time and labor. In other words, what else is your life but your time and labor? They own you. They think they own you. And they also said in the same report that the money of a depositor, when placed in the bank, the title transfers from the depositor to the bank. That's how the IRS, among other people, can come along and take every dime out of your bank account because it doesn't belong to you. It belongs to the bank. That's what we have to stop. But this is a supposition, and I'm going to tell you why. Is there a law? You bet there is. Most of them won't even know what it is, but it goes back to those of you that think your citizenship goes back to the 14th Amendment. Look out. Section 1, you didn't read Section 4, did you? Where it says right in there, and I'm going to quote exactly, that the validity of the public debt authorized by law shall not be questioned. That's why they can haul your ass into a tax court, which is Article 1, or a federal district court, Article 1, and you haven't got a hope in hell if you don't make the right arguments. That's how they do it. You've agreed to it. And the court, as I said again in their Ashwander rules, he who accepts the benefit must bear the burden. They're rarely ever honest enough to tell you what I just did when they dismiss your petition for writ of certiorari summarily without even hearing it. They should be required to do that because we have a right to go to that court. I'll go into that in another video, but we have an absolute right to be there, and they damn well know it. You know, they're treating us like corporate entities. And that's another video for another day, but the secret intent of the 14th Amendment was to make citizens out of corporations. But they didn't bother to tell anybody that. Only came out 15 years later. The case is called Southern Pacific Railroad versus Santa Clara County, very near where I'm living right now. I'm familiar with this case. And the court found out behind the scenes that this is what happened, and they were forced to rule in favor of the railroad, not the county, because now the railroad all of a sudden has these procedural rights that they were now bound to rule in favor of. And yet no one at the time they ratified the amendment was told that. Oh, that's fraud. And 150 years later, that there's no statute of limitations on it. And that's one of the things I argue in my brief on the 14th Amendment and with new states, is that if Congress can create these states and define the citizenship, and that's what they do, Title 8 U.S.C. 1401, I believe, and Section 1 of the 14th Amendment. If they can do that, that reverses the citizenship, because up until that time, the citizenship, the United States citizenship wasn't even defined. But you had it by virtue of the fact that you were a citizen pursuant to the Constitution of the state in which you lived. It's the states that had state citizens who were citizens of the United States. Now it's no longer that way. And of course, if there are no states, then they don't have to be bothered about any state constitutions or state citizens now, do they? So this is what they're doing to us. And they've taken it all away. And oh, by the way, that's one of the reasons they don't want you to know too much about the infamous Dred Scott case, which is legally known as Scott v. Sanford, 19 Howard 303. And yeah, you can read it, and you're going to find that Chief Justice Roger Brooke Taney, my favorite justice in the entire history of the court, said right in there that a black man had no right that the white man was bound to respect. Right in there, he said that. But you read the context he was talking about. They never tell you that. That goes back to the time when we were just forming the United States and around the Declaration of Independence. Had nothing to do with the current time in 1857. They don't want you to know that. What's more important is that the justices engaged in a lot of what's called dicta by the court. In other words, they didn't make any rulings, but they were anticipating that cases were going to come up, especially from the southern states, about what rights in the territories they had. If the people decide to move there as state citizens, what rights did you have, and what right did the government have to regulate you? Well, if you read 4.3, it looks like Congress has a lot more power there than they have. But you read Scott v. Sanford, and you understand if the court would have gotten cases, and they didn't because of the war between the states, they indicated what their ruling would be likely to be, is that you don't lose your rights by going from a state to a territory, and you can remain there indefinitely, by the way, and retain your domicile, for example, in the state of Alabama, but you might have a residence, say, in the territory of Wyoming. That's perfectly legitimate. You can have more than one residence. And all of them back then knew this. It did not secret like it is now. So this is the big deal, is that Congress is limited in the territories, and they don't want you to know that, because that's exactly what the hell it is they're doing, and what we have to stop. And we can. I'm enough of an optimist to believe that we can do that. Although some people that know me might confuse me as a pessimist, as described by H.L. Mencken, when he said that a pessimist is someone who, when he smells flowers, looks around for a coffin. Well, I might be under that definition, but I'm enough of an optimist to think if we still have a constitution and we still have people in positions of honor, power, profit, and trust in government, bound by an oath of office, we can get it done. That's why it's such a big deal to me to get into a federal circuit court, not a circuit court of appeals, a circuit court. And you're going to go to your attorney friends and say, oh, they did away with that in 1911. Yeah, they did on the federal level. but they couldn't take it away from the states who have concurrent jurisdiction under Article 3, Section 2, and the first Judiciary Act of 1789. Those courts are there. That's what I've not been able to get into. Once we get those courts back and go in there, the ball game is over. That's judicial courts who recognize our status, recognize our creator endowed rights, and now we can present real claims for violations of the Constitution, like what happened to me in Colombia. Now, we can do that. We can virtually keep them out. Those are our courts. They don't come in there unless we let them. And attorneys can't do it, because if the attorneys, State Bar Association members, pay attention here, you belong to a government organization. As such, you're required to either be appointed by the president or by a territorial governor appointed by the president. And I'm here to tell you that I'm sure Moonbeam up in Sacramento knows that he don't qualify for that. He's not a territorial governor, and yet we have a territory. This is how powerful this stuff is. And it's not that hard to understand. I'm kind of a bit embarrassed it took me so long to get it. I did, but you got to get over the big lie that we have states. Once it sinks in that we don't, everything else follows.
Okay, so Bill, give me, if you can, or explain the elements of why we don't have states, right? There's certain things that would make up a state, like certain things, certain elements that would make up a corporation. Yeah. What is it? What are those elements that are missing? Because, I mean, I think for me, like the first time when I saw your videos, you say there's no states, and I go, what do you mean? Here's California. I'm living in that state. And here's, the state of California is all over the place and all this. So what has happened, or what is going on that this isn't the case that you're talking about?
Well, there are some elements there, Adam. For example, as I just said, we don't have state constitutions now, and we don't have state citizenship. That was the original, and it still is the organic rule of citizenship here. There are none. Yeah, we have a California Constitution of 1879, adopted after the quote-unquote ratification of the non-existent 14th War Amendment. That doesn't count. The Constitution of 1849, by the way, for you people in California like me, still exists. And I got the Secretary of State by not having answered my certified mail inquiry about whether it had been repealed. It wasn't even acknowledged. And I've got certified mail on it. It's still there. So that's the one I go by. We also don't have states now that are represented in the Senate, courtesy of the quote-unquote 17th Amendment. That was purportedly ratified in 1913, not a good year for a constitutionalist. But if you read your Constitution, Article 5, that's the single exception, because normally you have to have 3/4 ratify them. Now, in pure point, in fact, we didn't have any states in 1913, but for this purpose, assume we did. Okay, now Article 5 says, it has to be ratified by 3/4, except that no state shall, without its consent, be deprived of its equal suffrage in the Senate. On the record, at least Delaware and Utah voted against the 17th Amendment. That's dead bang, plain and simple. I mean, there's no way that amendment's there, even if it's otherwise perfect. So the states are not only no longer represented, that's a hell of a control we have on the government. Put the brakes on, because all the states have to do is not send senators to the U.S. Senate. There's no quorum to do business. They can't pass laws. That's a hell of a big, that's one of the biggest ones there is, the control we have on the national government, especially how out of control it is now. They were just starting to get there in 1913, mind you. But the people behind this amendment knew damn well this is what they want to do. So the states are out of the mix there. We have states that, even if they exist, aren't represented. You're seeing now that the Supreme Court has no problem with one representative for every 800,000 people. Now, how in the world can you think about that a minute? 800,000. How, if you happen to occupy one of those offices like this idiot Jackie Spire we have out here, how do you know what in the world your constituency wants you to do and desires you to do while you're in Congress on any given subject? And we have the right to instruct our representatives, by the way. But how in the world are you going to do that when you have 800,000 of them out there in one district? It just doesn't make any sense. So we don't have that. So that's even more. And then with all this nonsense about this separation of powers, like I've been talking about with 123 and Article 4, Section 3, if Congress has the power to do that, that's a dead giveaway. We don't have states, because that takes care of all the separation of powers problems that should have been argued a long time ago. I mean, people couldn't have been that stupid 100 years ago when this was going on. They just couldn't. And this is how much control these damn New York bankers have of the whole thing. And they get people appointed to the Supreme Court they want. That's the real problem I have. The process, what it is today, you have to get reviewed by the American Bar Association, which has an irreconcilable conflict of interest with you and me and everybody else. Doesn't make any sense that they're the only ones qualified. And people, read your Constitution. You do not have to be an attorney to be appointed to the Supreme Court. What does that tell you? You don't have to be one. Yet in the California courts, you do. And yet all those people that belong to the state bar haven't been appointed by a territorial governor now, have they? Whoa, can you say conflict of interest? And what you do is you put a notice of recusal. They got it, by the way, in California, we have CCP, Civil Procedure 170.6, to disqualify a quote-unquote judge. I don't use that. Notice of disqualification. I'm telling them, I'm not asking them. And all of you, you don't have a single one that can rule on my case because you're not qualified to hold the office you're claiming to hold. And which, by the way, you're committing open treason to the Constitution, claiming to be a judge in a state judicial court of common law jurisdiction when you either knew or should have known pursuant to that oath of office. That ain't where you are. You're sitting there in a territorial legislative tribunal. And we start sending some of these bastards to jail if that's what it takes. That's what's going to change the legal landscape. People are going to say, wait a minute, we don't want to do that. We're actually going to do the job that we promised we would do. And if that happens, we get a big turnaround, on that ground alone. But there's so many ways to get where we want to go. And the offensive stuff, by the way, and the good news for me, and hopefully you'll see this and have seen it in my videos, it's not the fact that I expect to have a lot of quote unquote money coming in, which I do. I'm not doing it for that reason. And they recognized that at my first hearing in South Carolina, when I stood up there with the passion and the ability I have. There was not even any thought about me being there and trying to make a quick buck. It wasn't what I was doing. They know it, and I hope you do too. So yes, we're going to, all of us, maybe get good chunks of change here for all the violations they're doing to the Constitution. But we can do that at one and the same time, and sooner or later, it's going to get well enough known, either on the net or what have you, that now we're going to get enough people doing it. They're going to have to change the way they do business. That's the change I really want to see. And just like Moses, I might not get across the Red Sea with that one, but I'm setting it in place that people like you, Adam, can follow me. They're younger and have more years ahead than I do. But I'm doing what I can. I've got, family history tells me 10 or 12 years, who knows. Good health, thank God, I'm thankful for that every day. And you go after them and you just say, this is the way it is. And by the way, a quick note here for people that, because when I was sitting there in that jail cell 5 months in South Carolina, they never saw the volcanic amount of anger I had. They never saw it, not a day. Because for the most part, the people I was with, the jail guards and this, that, and the other, were not the responsible parties, and they wouldn't have understood it if I would have said what I was doing. By the way, it went by actually pretty quick, which jail time doesn't normally do, but I'm out there on days we weren't locked down 20 hours a day. And I'm out there with other inmates helping them and saying, hey, this is what you do. You tell your attorney to do this, that, and the other. I wrote down notes off the top of my head. And the people happiest to see me go were probably the opposite of the public pretender, because they were actually having to do their jobs once in a while with all these notes they were getting from their clients. So I had a good time doing that. And it's just something I could do, and I did do. And I hope it worked out well. I haven't heard from people. It's kind of hard with communications when you don't have any easy way to communicate. But in any case, it was useful time there. I'm not thrilled in one way that I had that happen, but on the other hand, if this spawns the revolution, I hope it does. That will have been time well spent. And it's the reason, by the way, that I'm doing what I'm doing. I'm the last of the family line. And I knew early on, I sensed it, but not for the reasons that I know now, that I couldn't just go out and get married and have a family, because that would, as it happens, compromise the efforts I'm doing now. They don't have any leverage over me like that. And those of you with families know very well when you have kids and things and you're dependent on the government for benefits and to survive, it's real hard to go in and make challenges. There's where I can help you. You won't have to worry because I'm going to have the paperwork done. You just get it filed and wait and sit back and see if the DA answers it. And when they don't, they then dismiss the case and we come back at them offensively and say, wait just a minute here. Yeah, you dismissed the charges, but in the process, you did so many premeditated criminal violations of my rights that we have a little something to talk about here. And we are going to have, and they're not going to have any affirmative defenses, and they won't have any judicial immunity. And think about that, people. How can they have judicial immunity in a legislative tribunal? Oh, and it gets even worse because all of them go back to this case called Bradley v. Fisher, where this BS started in about 1870. But you read Bradley, which I have, and I know damn well this case came out of the District of Columbia. And it is therefore distinguishable because what would apply there under Article 1, Section 817 has nothing to do with what would apply in states. And here's another reason, since you asked at it, if we don't have states, if they can use a case like that against us in a state setting, quote unquote, that tells you where we are. 1817, District of Columbia. And another note that I think I mentioned to you, you look up Title 26, so there's some boots in Title 26, Section 7408D. And it says in there, in effect, that if a taxpayer, and it should say quote unquote, cannot be found in a judicial district, he can be located, his residence can be located for all jurisdictional purposes in the District of Columbia. That's where the tax is valid, not in a common law state like we're supposed to have. That would be impossible. They couldn't do it. But in the District of Columbia or a territory, take your choice. I think it's 1817 myself, but you know, that's how they do it. And by the way, you look that up, and another statute I have, 26 U.S.C. 6305B, you probably never heard of, where it says that no court of the United States, whether authorized under Article 1 or Article 3, shall have the power to restrain the assessment of taxes by the Secretary, which was the Secretary of HEW at the time, now Secretary of, what do they call that, Human Resources, whatever. But when you sign up for Social Insecurity, you've just waived your right, apparently, to go into any judicial court, which we have a right to do, and challenge them taxing you. But here again, if you've been paying attention, you'll note that I've said that those courts you can't go into are Article 1 legislative tribunals. There's no problem with that. What you can do is go into an Article 3 circuit court, federal circuit court, and your state court exercising that jurisdiction. They can't keep you out of that one. Because if they would have said that in the statute, that's a clear bill of attainder. That's why they're getting away with it. Because you can't use that argument. It isn't what they did. But you have to understand what they're doing. But the point I'm making here is that laws like this, you go and look, and my God, these have been around 6305, like 60 odd years. And there's maybe 7 or 8 cases, and all of them have to do with the collection of child support from deadbeat dads. There's not a thing in there that has to do with the issues I'm raising. But you go to the USC, you can go to your law library, United States Code annotated, Title 42, Section 1983. There's a statute that has close to 3 volumes in the USCA. 3 volumes on one statute. And it's horse hockey. 95% of those cases get thrown out on the first motion. You know, failure to state a claim, and they never tell you how to state a claim. That would be nice to know, wouldn't it? Failure to state a claim upon which relief can be granted. That's another change we may see with these 1983s, because I'll be helping people if they want to file a claim like that with the issues we're raising and the absence of jurisdiction of the court that we can prove. Now we're going to survive that initial motion if it comes to that, and it won't. If it does, we now go from a 9-to-1 dog to a 9-to-1 favorite. And if we lose, it sets us up to get it reviewed in the Supreme Court. That's even worse for them. That's how strong this stuff is. And that's why you're going to get paid off, because they can't afford. Because if we get up there one case to the Supreme Court and they say, yeah, you're right, across the country, coast to coast, every case. That's how bad that they can't possibly want that to happen. That's how the system works or doesn't work, depending on your point of view. But knowing that, I'm sitting here, I don't get excited about too much. But when I read these two cases I've been talking about here, Franklin and Montana, and I said, there's no way they can defend this in any way, shape, or form. If we're talking about states here, there's separation of powers, and Congress cannot delegate authority like this. Wow. And if they can do that, the other question you asked, and I know far when we get there, if they can do what you say they can do in these cases, what limit does that power admit? Or is it like their Commerce Clause powers and it doesn't admit of any limits? And if that's the case, now we know we have no states, because that's not the way it was set up. It's not even close. Not close. And you people to get my race on this, the 1, 2, 3 break and things like that, you read what's in there and you read what they said and realize that that section has not been amended. And by the way, in both cases, the court referred to Section 2 of the 14th Amendment that they claimed amended 1, 2, 3, which it didn't. Well, the amendment doesn't exist. Even if it does, that's a very minor change. There's nothing that changed the original intent there. It's just that now they went from counting 3/5 of the black population in the South to counting all of them. But in terms of the change with 1 in 30,000, it says nothing about that whatsoever. And yet the court today thinks it's perfectly fine to have one district, with 800,000 people, and that's all you're entitled is one representative. They are not looking at the same Constitution we are. Simple as that. Let me catch my breath here. If you have some more questions, fire away.
Kind of off topic, but something that I was thinking of today, at least in my case, is the presumption, or my question was, is a presumption required to be disclosed to you in like what a bill of particulars, the nature and cause of the accusation? Because it seems like to me, like especially in my case, I didn't know or understand that that's what I was. That's the presumption is that unless you get a contractor's license, you're incompetent, right? So they've made this sort of ex parte determination that until you get their license, you're not competent to do this building trade. Well, then you go to court and you don't even know that you're operating on this presumption because no one's telling you that. And unless you have schooling and an education to understand what law is, you don't have any idea that that's what they've done. So is a presumption required to be, or there's another one, a presumption and a, I can't remember the word right now, but is that part of your due process right to be disclosed of the nature and cause of the accusation against you?
Oh yeah, now in your case, as we know, it's what they're calling a civil case. It isn't, because it's subject to federal, regional, martial law rule. That makes it at least quasi-criminal. And the Bill of Rights, the BOP does come up, Bill of Particulars, under Amendment 6. But if I cite that amendment, I always cite the unpurviewed 6th Amendment that would apply in the territories, not the states. And I also cite the 9th Amendment, which is even better, because that's beyond the Bill of Rights, and that applies across the board. So not only it does that, but the prosecutor, or in your case, the plaintiffs, have the burden of proof to sustain jurisdiction of the court. It can't be any plainer than that. In a criminal case, quote unquote criminal, that's why I asked in the Bill of Particulars, among other things, for the prosecutor to identify the definition of person, quote unquote, because if they do that honestly, the only kind of a person they can deal with is a corporation. And once you realize that, and at one time, and I've lost it, but years ago when my mom was still alive, I had her do an affidavit for me, notarized affidavit, that I was not a corporation, and the state of Maryland had nothing to do with creating me. It was between her and my dad. And I kind of still wish I had that. And it was tongue-in-cheek humor, but I'm not a corporation, you're not, and most of you out there are not corporations, and yet they're treating you like that. That's because the 14th Amendment made citizens out of corporations. That can be proven. So if it says in the 14th Amendment, all persons born in the United States and subject to the jurisdiction thereof, which we're not, are citizens of the United States, and they include corporations in there, then the way you have to interpret that if you're sitting on the court as a judge is that it means corporations. It can't mean both things. It can't mean real people like you and I and corporations. They're separate entities. Now, the issue you said about incompetence, and you're dead on with that, because that's exactly what they think we are. That's what I ran into in Columbia, South Carolina, when they thought I would be incompetent to represent myself. But I laughed. I said, my goodness, you people apparently didn't read the documents I sent you, 150-page writ of habeas corpus. And I think going in, they must have assumed that I downloaded it off the internet from some other place and was trying to use it to make a fast buck. Well, when I showed up there with a gun to my head, they found out quickly that wasn't the case. So, yeah, but they presume we're incompetent, and yet there's some real problems with that, because if we're incompetent, how would we be in possession of the competence to form the criminal intent to do the crime we're charged with? Hell, that's an affirmative defense. That's in California. That's the idiot defense. Idiots can't be prosecuted because of that. Now, if we're incompetent, as I was in Columbia, and all of us are every day, how is it when you go into the voting booth on quote unquote election day, and trust me, people, there are no elections. How is it that all of a sudden we magically get competent on election day? Damn. And then you have to have one of their licenses to do business, and they don't tell you the legal definition of license out of Black's Fourth Law Dictionary. Permission granted by competent authority to do an act that without such permission would be illegal, a trespass, or a tort. Well, wait a minute. Article 1, Section 10 says that no state shall pass any laws that impairs obligations of contracts. So wait a minute, if we have an unlimited power to contract, how in the world can the state limit that by attempting to license us to do something? That escapes me. I haven't got an answer to that question. And think about that in terms of, for example, driver's licenses, marriage licenses. You need their permission to get married. And one of the big secrets there, if you're not aware of it, is that marriage license really didn't come into vogue until the early to mid 1870s, after the ratification of the 14th War Amendment. And now you got everybody who's subject to the generally subject to the jurisdiction of the United States. So now all these marriage laws all of a sudden, will take on a different meaning entirely. And at the time, there was no license. You just went wherever you're living, went into the church, you got married with common law marriage. People knew you were living as husband and wife. There wasn't any question about it. You had a right to do that. Now they think you don't. You need one of their licenses. And to get one of those licenses, by the way, I think in every jurisdiction in the country, you have to present a social insecurity number, which I found out was voluntary. It comes under Title 42 USC 302A8, where they say it's voluntary. And I've got my own letter from the then Commissioner of Social Security saying, yeah, you're right about that. It is voluntary. I got rid of it. When I discovered that, I said, hey, what I want to be in here for, in a system in which they can take all your property in the form of your time and labor, and yet you have no right to the benefits that you think you earned. Exactly why I got rid of it. And if you're in a position to do it, I urge you to do the same thing. Now, those of you, again, that are out there with 3 and 4 and 5 children, maybe I'll do some special paperwork, and you can indicate to Social Security, the Department of Treasury, whoever, that you would take this step, but for the fact that it's impossible for you to do it with the system of government we live in today, and particularly one that uses paper money, which this government's been doing since 1913. That's the real problem. Unless until we get rid of that, then we can't do that. And that, by the way, you read the Federal Reserve Act, that's a video for another day, but you find out Section 95A, talking about delegation of powers, delegates massive amount of authority to the president to declare emergencies, pursuant to which this paper fiat currency can circulate. This might as well be military script in Korea. It's exactly the same venue it circulates in, not a state judicial district. This is another reason there's no states. This couldn't circulate here if there were. And it would be a trespassive jurisdiction for an IRS agent to come against you if you got paid in gold or silver. I don't even think they would do it. They won't accept payment in gold and silver. They're right not to do that. That's taking a property without judicial process, a bill of attainder. That's why they don't do it. They know better. So this whole thing, there's a lot of crap here that when pieces start to come together for you, and they will for all of you, once you study 4 or 5 key issues and you understand them, then you get the thought processes that lead you to the conclusions that I've independently reached, and that my paperwork, I don't say it if I can't prove it. I figure 97% of what I put out there, I've got the goods. The other stuff I'm working on, but 97% is a pretty damn good percentage. And I'm just working to get better and get it all there, especially in the area of social insecurity trust funds, which I understand that people of my age, quote unquote senior citizen, have upwards of a $30 million trust fund there that everybody else can go dip into except us. And that's a video for another day, but trust me, from what I've seen, I believe every bit of it, but I don't have enough in hand to put it out there yet. When I do, it'll come out in a video just like this, and I'll explain it chapter and verse and see why it is that we can't get to our own trust account. And here we are, by the way, if you want to use trust law, you consider ourselves, and I do it in some of my legal paperwork, identify myself as a beneficiary of the trust known as the United States. And I address the public servants as trustees. Beneficiaries tell trustees what to do, not the other way around. And that gets more attention than you would think in some places, because people that get trust law and understand what you're talking about, that's the relationship. And it goes back to the state citizens having power over the government that we created. We ordained and established all of it to secure the blessings of liberty to ourselves and our posterity, if you can believe the preamble to the Constitution. Well, if that's true, I challenge anyone to show me any liberty we have existing today for anyone, let alone our posterity. It isn't there. Nothing you do these days. I mean, everything, they think they control it all. And from Washington, D.C., my former hometown, damn, if they would have taught me this stuff 50 years ago when I was in high school there, all hell would have broken loose a lot sooner than I think it's going to. But I'm sure they didn't teach any of you either, so don't feel bad. You just don't get this in usual history books. And in fact, I'm going to do a list of books that you can look up. I might be able to provide some, but the books that I've used, and some of them go back to the 19th century. And they're much more honest and forthright about the situation and explain things. Well, you couldn't lie about it then. It was within living memory about the war between the states and other things like that. And in the admission of Maine and Missouri, and that's a video for another day. I've done some on it before, but I need to revisit that. That's the most important issue that came before the Congress in the history of the country. And like I said, another day, but what happened was that they want to let Maine come in as a free state, but they refused Missouri coming in as a slave state. Now, on the surface, that appears to invoke the issue of slavery, although I think even then it was a context, not the issue. But the problem was the South knew if that happened and Missouri came in as a free state, now they're going to lose control of the Senate and allow the government to pass laws that would be very hard on them, which is exactly what happened. By the way, that's what led to the nullification crisis 10 years later, when South Carolina refused to enforce federal import and export laws. And they were right about that. Andrew Jackson, who's my second favorite president, goofed on this issue. We were right in South Carolina. They should have had the power to do that. But that said, and we could have broken apart in like 1820, and had that happened, wow, you wonder, because I think that Great Britain would have come in on the side of the South, just as they would have in 1860, but for some efforts by people like George Boutwell, and it's another one that knew a lot about foreign affairs, which is not Lincoln's strength, and they kept Great Britain from coming in. In 1820, they might have, with the idea in mind, to take over the South once they broke apart from the North, and then come back, reconquer the North, and get back to the way it was in 1772. Could have happened. That's how important Maine and Missouri, and you read the speeches of the congressmen at this time and compare it to the crap we have today. I'd be happy to have 1/10 of the intelligence of those people that we have in these damn seats now. You read this stuff, sometimes it brings you to tears. They understood it, exactly what was going on, and they said it on the record. That's how important it is. And a lot of that's in my paperwork that you can get, my jury instructions, my briefs. I have extensive citations from old debates like that, talking about. And that's the other thing when he said, well, there are no states. Yeah, this is one of the reasons, because especially after the admission of Minnesota in 1859, this union ceased to exist. And now you read these debates talking about admission of new states, and you see they're talking about, if you admit them to a union in which Congress can dictate the terms of their entry into the union. That's not the same union that was formed by the original 13 colonies. That's not what happened then. It's not what should be happening now. And yet Congress can do that. In fact, a big deal for me personally was in 1912 when Arizona and New Mexico were admitted into, not this union, but admitted into the United States. And during the course of those proceedings, President Taft, who should have known better, by the way, later Chief Justice Taft, tried to intervene and prevent Arizona from being admitted. There were some problems there he didn't like. I don't recall the details, but nevertheless, that again, that's Article 4, Section 3. That's Congress. The president has nothing to do with the admission of new states, does he? Except if those states are not being admitted into this union and they're being admitted as provisional states, the president would have control over them as commander-in-chief of the armed forces. Oh, they're going to go nuts when they see you raising issues like this. Assistance to counsel, right to remain silent. Who the hell cares? These are the issues we want to get at. This is how you get them and say, wait a minute, no states, they were not admitted into this union. And if they were relegated on who knows what constitutional authority to some lesser status. And for those of you that really got a bug up your ass about this, you can take a look at a case called Jones v. United States, 137 U.S. 202. And it talks about a territory that the court ruled was appurtenant to the United States. It's called the Guano Islands. It's just some islands in the Caribbean that at the time were being used. Some private individuals went there and found out there was a lot of birds crapping all over the place, and that fertilizer could be used for industrial purposes. So they set up to do that. And during the course of the affairs, they had some kind of insurrection on Guano Islands. People got killed and some people got prosecuted and were challenging the venue of the court because it was held in Baltimore, Maryland, and the Supreme Court sustained it. But they said in doing that the Guano Islands wasn't even a territory. It was merely appurtenant to the United States and therefore subject to control of the president. And I'm going to bet you find me a dumbass that can recite that case to you. I'd love to see one. There's probably none that would even know that. But I do, and I did in Columbia, South Carolina, and they finally figured out. Wow. So anyway, don't be going too long on that, but you get into this stuff, and this is how it grasps you and gets hold of you. And that's why, and I hope people are seeing here, what I have is the passion to do this, because I know how important it is. And just a quickie of that, there's a fine mini-series on John Adams, and I'm not a big fan of Massachusetts politicians, but it's a really fine series, and most of it was set during the time period where he, Franklin, and Jefferson were over in France in the 1770s, trying to generate support from the French government to help us with the American Revolution. Now, at that time, Adams had 4 young children that got left alone with Abigail, and of course, no telephones, no internet, nothing. But he understood what he was doing was more important, and there's few things more important than family. This was one of them. It's why I do what I do now and why I don't have a family, because I recognize, and I have for 30 years, that I can't put anybody in that position to be the primary caretaker of children when I can't get in there and carry my own weight. So as much as I would have liked to have had children in some ways, I get it. But anyway, it's a very good video. And what you don't know going in, and I happen to know this about that whole business, they're over there in France. And we later signed the Treaty of Paris, 1783, that ends the American Revolution, right? Who signed it on the other side? Who signed it? King George III, King of England, no problem. King George III, King of Ireland, no problem. King George III, King of France. What? Now you're going to tell me that Franklin, Adams, and who did I just say there? And Jefferson went over there, and they did not know that, and they were trying to get funds from King George III to help fight against his own army in America? Has the fix been in from the beginning here? I don't know, Adam. I don't know. Has it been in? And when you realize by the first Secretary of Treasury, Alexander Hamilton, being started on this bastard, but he, prior to this, had been an agent working in the city of London for the financial powers that be there, particularly the Rothschilds. And yet he turns up as the first Secretary of State, and they create the first Bank of the United States in 1792. Gave it a 20-year lease on life. And if you do the math, and you tell me 1792 and 20, 1812. Ever hear of the War of 1812? I suspect this is really what went on there. And as you know, if you studied your history and you people out there, that we had a second Bank of the United States that was came about in 1817 for 20 years. After all this BS from the War of 1812 calmed down, and they got, who was president then? Madison, I believe. And it got chartered, and it ran for 20 years and expired in 1837. And this is one reason Andrew Jackson is number 2 on my list, behind only Andrew Johnson. And these are probably 2 that are on the dead-ass bottom of everybody else's list, but not if you know what you're talking about. So he ran this whole campaign in 1832 to get rid of the second Bank of the United States and Nicholas Biddle. And by God, he did it. He understood the problems with this kind of central banking. He was the predecessor of the Federal Reserve. But what happens? Oh my goodness, 1837. The bank goes out of business. We had the biggest financial panic in the country to that point in American history. Now, what people don't know about this is that there was a company there that made a lot of money called the George T. Peabody Company. Made a lot of money by borrowing money from the English bankers and buying up stock short and this, that, and the other. And that's maybe not so bad at first blush if you think about it. But when you know that the George T. Peabody Company later turned into J.P. Morgan Guarantee Trust, you know where these bastards got the money from, doing crap like this. So yeah, we got rid of the second bank, and we were comparatively good hands for the next 20 or 30 years, but along comes the war between the states, and I'm not going to go into it now, but trust me, the bankers made out beautifully with that event. They loaned money to the government, and they got them to issue greenbacks, which could be used for all debts, public and private, except the public debt. Those bastards got paid in gold and silver, and all we had was paper money that was worthless. Damn. Don't get me started.
Wow.
So yeah, it's just the way it is. And people, I apologize. I know I'm putting a lot of information out there, and I'll do it better in future videos. And I'm going to be doing some paperwork on this. I'm not sure in what form, whether it's going to be a book, a series of essays. I'm not sure yet. But it all makes sense when you look at this stuff seriously, and it doesn't take as much time as you think. I'm going to try to make it easy and have a lot of shortcuts for you, a lot more than what I had to do it. And you say, my goodness, you go from A to B to C. It isn't that hard. And it throws them for a loop on the other side. And you experience that bit of power I got, especially in Colombia. When you experience that for the first time, that's, wow, talk about intoxicating. That it never leaves you once that happens. And when, I talk to them, and in fact, some of them have been friendly that I have talked to, some of the, especially the court executive officers, and respectful, but they're in an odd position since they're appointed by the presiding judge. They're not elected constitutional officers. So there's not a whole lot they can do. They have to follow orders. But sooner or later in our offensive lawsuits, we're going to name people like this as defendants and say to them, fine, we'll allow you to invoke the proverbial Nuremberg defense if you tell us who it was that gave you the orders to do what you did. And now we get higher and higher in the food chain. And that's when they start to call you up and say, what do you want? Because they can't stand the heat. So they have to get the hell out of the kitchen. And I'm fine with that. And I hope you people out there will be too once they get things in place. This will take probably a good week or 10 days. Maybe after Thanksgiving before I have the paperwork in place, but I will have it in place in a couple of 3 different versions, depending on what happens to you in your trial court, because there's a couple of different ways it can go. None of them good for the people on the other side, because the DA has never even acknowledged any of my papers, let alone answered them, but they have the sworn duty to do it. That leads to a lot of settlement money on our side when we sue them for violating their oath of office. That's a lot of leverage, and we should take full advantage of it. When we start doing that and waking people up, That's when it's going to lead us to change, and maybe some other things that we get done in the meantime too. So yes, I want to get to 904 with some of these issues, and hopefully that'll happen within the next year or so, especially out of the South Carolina case. I'm not going to waive my rights to have issues decided. I might waive them in terms of being able to go after them for any criminal penalties or such that may develop from the rulings of the court. If I get a fair settlement, that's probably a fair trade. But I don't want to trade the right to get the answer to the questions. I've got that status and standing that not many of us have right now. I'm going to teach you how to get it and how to use it, and how to use it in concert with your 14th Amendment citizenship. I believe that can be done. You can be both, believe it or not, because you got the gun to your hand with the 14th Amendment. Nothing you can do about that. That's duress and coercion. But at the same time, you can say, wait a minute, but for I would have this other citizenship. And or if you're a non-white, for example, and you're from an African nation, say you would go and plead in the courts as a member of a sovereign African nation. And believe it or not, you would have as much, if not more, standing in a federal circuit court than I would. That's how it was originally set up, and it made sense to do it the way they did it. So there, if we get to those courts and you do away with this concept of civil rights, you people are being led down the garden path and have been from the beginning. With the civil rights crap, all that's doing is using federal, regional, martial law to take over the states of the South and really all of the states. That's what the real intent was. And a quickie on that, by the way, and I've got dead bang hard copy stuff in my paperwork, you'll see it, that the first 700 cases that went to the Supreme Court based on the 14th Amendment, 700 cases. This is in the late 19th, maybe early 20th century. 700. How many of those do you think involved the rights of freedmen? Think about this, people, while you're out there. And I'm going to tell you how many. 8. 1%. All the rest of them involve corporations. If that doesn't tell you what the real intent of the amendment does, I'm hard-pressed to know what will. 8 cases, and one of them, by the way, was a very infamous Plessy v. Ferguson case that I believe the court correctly decided, that was later ostensibly reversed by Brown versus Board of Education, a subject matter for another video. And some of you people initially won't like what I have to say about that, but when you understand why I'm saying it, that's what I can get across. And especially, to blacks and other people of color, you understand what's going on there. And you'll get it that the Supreme Court was making it up as they went along in that case and other civil rights cases. And the curious thing there that I don't know, Adam, I wonder, because right at the time these cases went into the Supreme Court, at the time, Fred Vinson was the Chief Justice, and he'd only been Chief Justice for 7 years. He was like 60 years old, and he mysteriously dies. I don't know, I'm not going to be that much of a conspiracy theorist, but you do have to wonder. I've not dug anything up on it yet. But he got replaced by Earl Unwarranted, and for more than one reason. From what I hear, Tricky Dick had a lot to do with that, because Warren, if you don't know at the time, was the governor of California and would have been a big candidate for the presidential nomination of the Republican Party after Eisenhower. And that's what Nixon wanted to get, and what he did get in 1960. So he decided to take care of the problem by having an old bubblehead, which is what Ike was called, appoint Warren to the Supreme Court to get him out of the way. Well, the point I'm trying to make here with Vinson is that he was from Kentucky, and his view on the civil rights cases might have been distinctly different than some of the members of the court. And in fact, there would be a chance the court might have come down 5-4 against Brown in that case. It would have been anything but unanimous. So you do have to wonder, given that circumstance, I don't know. If I get more information, I'll let people know. But you know how, especially with what I know about the events in Dealey Plaza, we're not going to go there in this video, but trust me, that's not anything near like what it appeared. I mean, Oswald wasn't even Oswald. He was a federal agent named Alec James Haddell for openers. So that whole thing, and the history of the United States that I'm familiar with, that you don't see in history books, give you good reason to wonder about things like this. It was very convenient for that to happen at the time it did. So anyway, those are videos, subject for another day. I don't want to get into the civil rights stuff now, but it's important for you people out there to get it. It doesn't matter who you are, what you are. Understand that they're screwing us all over. And your civil rights leaders are getting ahead on the backs of their constituents by doing it. And some of them high enough up in the organization know that. And they're doing it anyway. Damn. Well, like I said, we're not going to go there. Another quick question we have time for. We don't want to run this video too long, but I'm fire away if you have another one.
I'm good to go. We got about an hour under our belt already, so.
Oh, do we really?
Maybe
Well, it didn't seem like that. But then, I apologize, people. I know we've gone on a bit long here, and it just the style that I have. But trust me, I can prove everything I say. I've got it in black and white. I don't make it up. You get my documents, you're going to see the proof. And I've not yet anybody complain and send it back and say, you're an idiot. You're lying about this. Hasn't happened yet. Not going to happen. So good. Well, I'm glad we had an opportunity to do this, and we'll do this. Well, who knows? Not going to put a time frame on it, but we'll get together again, week, 10 days, who knows, pending further developments. And I'll have some more to say on, especially the Colin Kaepernick situation, by the way, and the furor that's kneeling for the national anthem, which isn't what I would do. As I said in one of my earlier videos, I would be standing up and flipping off the flag and the national anthem. But it's not what I'd be doing. I'd be flipping off the government behind it that's using those, fronts to make it look like there's a real government. That's what should be going on here. What they're using, and notice, by the way, most of the flags are getting better about it these days, but a lot of the flags you see have that yellow fringe around them. And I've got dead bang black letter law that says that's a military standard. And that's what you see in these federal courts you go into, military jurisdiction. That's what they're exercising. Goes hand in glove with it. That's exactly what they're doing. And by the way, I've not been able to get into a federal court since 2001. So in earlier times when I started out, they actually had state flags in federal courts. I understand these days they do not, and they don't need them. Here's another case. If we don't have states, you wouldn't need the state flag in the federal court, would you? It's not bound by state law. There's another reason why we don't have states, because now it's all federal law. Everything and anything you can name, it's all the civil rights or what have you. And this is what has to stop. So anybody gets in there and you see that, let me know if they do have a state flag, and if they do, does it have a fringe around it? I have no way to know since I don't have any of their IDs that I can get in the damn building. But that's a great thing for all of us, because if we don't have the ID, they don't have any control over you. That's why I got rid of all of it. I don't need government ID. Like my first law teacher said, my mom told me who I was when I was 3 years old. I never forgot. So I'm the best evidence of who the hell I am. I mean, just simple things when you think about it. And you get their ID, they own you. So those are things we got to change. Anyway, like I say, we probably should wrap up. I'm going to be driving people mind-bogglingly crazy here that haven't been exposed to stuff like this before. But I'm telling you for the last time, I don't make it up. I've got dead bang proof of every bit of it. That's what sets us free, and it's what sets your family free in the bargain. You teach your children, and they teach their children, and now they can't keep doing this. That's the important part. So that said, people have a good night. We'll reconvene when circumstances warrant. And just one final note before we go. I don't know why the hell he didn't get Clayton Kershaw out of Game 5 in Houston. I still haven't figured that out. Blew the World Series by doing that. Anyway, that said, I'll have more about college football in the next trip. Trust me, that's what I really do. And almost as well as I do law. So anyway,
thanks, Joe.
We'll get together next time.
All righty.
Okay, thanks.